Good morning, everybody. Welcome to the first ever ABO webinar. So do bear with us as we attempt to fathom out some of the technological challenges that go with being, for me, being over 50 and therefore struggling to quite follow how all this works. And the way we're going to run this webinar today is that we're delighted that we've got here Alison from Wesley Gryk, who's going to talk to you through the main issues relating to immigration into the UK from the EU. And there is the facility for you, I believe, to type up your questions as we go along. And we will, at the end of Alison's main presentation, we'll then look at the questions that you've submitted, and we can then run through those with Alison just to clarify anything that you wanted to add to the core presentation that she's given. So I hope that all makes sense. It's all a bit weird, the fact that we don't know necessarily where you are, but we've got a good turnout for today, we see, including some people dialing in internationally, which is terrific. So without further ado, I would like to hand over to Alison and let her get going, and then we will take it from there. So over to Alison. Welcome.
Morning. As I've been introduced, my name's Alison Hunter. I'm a partner at Wesley Gryk Solicitors. And what I'd like to do is really a slideshow, so a PowerPoint presentation where you'll see me in the corner, and we'll put that up in a minute, and take you through really what's happening at the moment in immigration law for Europeans in the United Kingdom, and slightly beyond that, as much as we know. So I can tell you a little bit about what we know beyond that, but a lot of it is still very, very uncertain, as you'll appreciate. There are 3.6 million EU citizens roughly in the UK. Nobody knows exactly because nobody's ever counted them. We've never registered people who have come into the United Kingdom, but that's the sort of numbers that we're talking about. The government has stated that 1.8 million have already registered on the EU settlement scheme, 800,000 of those in August and September. I'm calling that the Boris effect. Everybody got a bit scared and decided they had to do something. But that means that they now have about a backlog of about 350,000 cases sitting at the Home Office. And as you can appreciate, that's causing some distress because these applications are meant to be dealt with very quickly. I'm going to put up my slides now. The message that I really want to get across is that all Europeans who are in the UK now and want to continue to be here do need to register on this scheme. There are very, very few who don't have to. And if in doubt, they should register. It's a very easy and straightforward application. And so if you have people working with you or people you know, really encourage them to do it. At the moment, it's not necessary for employers to have them registered on this scheme, but it will be. And the sooner they do it, the better, basically. So I've put up who needs to register. It's pretty obvious. But it is a little bit wider than just EU nationals because it includes people from other countries which I've listed there. The Swiss have a slightly different arrangement, but basically for this, what I'm talking about today, they can use the same system. In addition to these European nationals, there are also their family members. So any family member who is within a family which has a European national will also be able to register. It's obviously for Europeans, they can register in their own right, but if the family members are third country nationals, so not European nationals, they can register as well. The Irish are in a slightly different situation. They can technically register, but they don't need to. They're going to fall under a different regime, so they will always be allowed to work in the UK. They will always be able to come in. They have a different regime, the common travel area, and so they don't have to worry about this system. And you as employers or people who are working with them don't have to worry about it. So moving on, let me just explain how this system works. It's a two-stage process. The first stage is that you have to prove your identity. And this is where the very magical EU Exit ID document check app has been construed by the Home Office. You can download it very easily on an Android phone. At the moment, you can't download it on a iPhone, although the Home Office had promised us that that would be in place in October. It's still not in place, but they're saying now by the end of the year. So you do need somebody with an Android phone and a fairly up-to-date Android phone. You can then download this app. But if you can't do that, or if you've got people who don't want to do that, there are also ID document scanning locations. Most local authorities, especially in London, are now offering this service. Or you can actually send your ID document to the Home Office by post. I wouldn't advise the latter. That's when things get lost. So if in any way people can do their identity by not doing this, sending the passport in, that is definitely preferable. So that's the name of the app, EU Exit ID Document Check app. Download that, and that will be the first page that you see. So what you need to do to make this application is your ID document, and the ID document can be a passport or an identity card. It needs to be chipped. So it's important that it's chipped. So there are a lot of Italians in particular who have ID cards that are not chipped. They can't be used. They would need to use a passport. The next thing it asks you is, are you a Swiss EEA or Swiss national? If you can say yes to that, you just move on. If you say no, that's probably because you're a family member if you're using this. So you have to have had a biometric residence card, which has already been issued by the Home Office. So you will already have been given some sort of immigration status that allows you to remain here. You then take an image of your passport, and the way you do that is you hover the phone over the passport, and it's fiddly, but it's not impossible to do. And you have to sort of hold it there until it's in the right place, but it's very, very clear how to do it, and you can't proceed unless you get it right. Then put in your contact information. It's important that you can access that phone whilst you're doing it, because they then send you a code to allow you to proceed with the application. Sorry. You then confirm that PIN by putting it into the phone. And then you have this surreal bit where you actually just put your phone on the passport and it reads the chip. It's very slightly scary. You have to move it around until it picks it up. But what it's doing is somehow, don't ask me how, dragging the information from your chip out of the phone. And on that chip is all your personal data. So they're checking that against the photo that you've sent in. Once it's done it, it bleeps at you and you can move on. You then end up scanning your face. So for us who are over 50, that is challenging because it's this selfie thing. And it flashes different colors at your face. So the first poor client that did it, I was absolutely horrified because it goes blue, green, and yellow. But then again, once it's scanned, you move on. You then take another selfie, which is a photo of yourself. Fill in some information, which is very straightforward. Verify your email address. And then it tells you to go on and complete the online form. So at that point, you have verified your identity. So it's really, really straightforward. The only thing you do need, and this is important, is an email address that you will keep, because you will need this to access things in the future, or the European national will, and you need a telephone number that you will also keep into the future, because that will be the way that the Home Office contacts you in the future. If you're using the app for family members, as I said before, they need to have a current biometric residence permit. That's a permit that they will have been granted already by the government to be allowed to stay here. If they haven't got that, they'll have to either go and have the identity document checked somewhere else or send it into the Home Office. Then you move on to an online application form. This goes through 5 different stages. It looks at your identity, then asks you some questions, which I'll go through briefly. It talks about your residence in the UK, whether you've got criminal convictions, and then sometimes they want you to have another, upload another digital photo. If you've used the app, your identity has been verified and you won't have to produce a digital photo. And so it will, the section will appear as complete on the form already. If you haven't verified your identity and sending in your passport, you'll also need to upload a digital photo. So that's all very straightforward. Then in the application type, you're putting in your personal details. You have to say what national you are, and you have to say if you're a dual national. Now this has caused some problems because I've got Europeans who have become British. British people are not allowed to use this system. Some Europeans are very upset about this because they think they'll get a lot of advantages from it. They don't really, but dual nationals can't use it, but you do need to declare all your nationalities on it. You also have to declare your current immigration status. So if you have been granted some sort of immigration status, either under European law, so you've got some document, you will be able to fill it in there. Or if you've been here a very long time as a European and you've got indefinite leave to remain, you put that in there as well. None of this matters in the sense of what you're going to get out of it at the end, but it's important to be accurate. Then you fill in various things like your address, your other names. It's very, very, very important to put in if you've ever been known by any other names. And the reason for this is, I will talk about it, is about the automatic checks. So what happens is, with this information, the Home Office goes straight to HMRC and the Department for Work and Pensions and looks at all the data that they hold on a person for the last 7 years. And the reason they're doing that is they want to check if you've been here for 5 years. If you've been here for 5 years, you will get settled status. If you've been here for under 5 years, the person will get pre-settled status. And so they are dragging down information from HMRC to see if they can just verify the residents in the UK. So it's slightly scary because they literally do it within minutes whilst you're filling in this form, and they get dragged down that data. But it's very helpful for people who have paid taxes for 5 years because they don't have to send in any other further documents. There are then criminal checks which are completed by the Home Office. So you have to fill in any criminal convictions that you have. Most people are not going to have to worry about any criminal convictions. Criminal convictions only become important if they are extremely, extremely serious, because this is a European test, which is well above any UK immigration test. So you can actually have committed quite serious crimes and still be allowed to remain here. You then confirm that the information that you've provided is correct and that you're eligible under the scheme, so that you are a European national and you filled out everything correctly. So what's important are the outcomes, and this is important for employers to understand. If somebody has settled status, although it's being called settled status for political reasons, it's actually the same as indefinite leave to remain. So when you're looking at the employer checklist, if you can see somebody who's got this status, you are allowed to employ them and they will be able to remain here indefinitely. The only way they can lose this status, and this is very advantageous compared with UK immigration law, is if they leave the UK for 5 years or more and don't come back. As the law stands at the moment, if they were to go out for 4 years and 11 months, come in for a day and then leave again, that would reset it so they get another 5 years. So it's actually very hard for Europeans who have been here for 5 years to get settled status. They really do have to have been absent for a very long time before they will lose this status. And it's important for Europeans to understand that, because they can maintain their status by just coming back once in every 5 years if they want to. Now, if the Home Office has picked up documents for 5 years from tax records, they will automatically give people settled status. You have to have 5 years of continuous residence, which means you mustn't have been out more than 6 months in a year. But sometimes, because of the way tax records work, sometimes you will be granted settled status even if you've been out for longer. But that is really the 5 years continuous residence is what you're showing. If they can't pick up the records for you, they will ask you to upload documents to show that you have been in the UK. And so what they're looking is for the most official documents that you've got. We very much ask people to bring in council tax bills, because that will show that they've been in the UK for a year. Well, that's what the government says. It doesn't really show you've been in the UK for a year, but the government accepts that that means you've been resident for a year. They'll also upload utility bills, bank statements, anything with your address that shows that you've been here. If you can't show the 5 years, or you haven't been here for 5 years, you'll get pre-settled status. You need to build up 5 years of pre-settled status before you can get settled status. And you can then apply as soon as you've got those 5 years for settled status. So you build up those 5 years, you get to, from pre-settled status to settled status, and you move on to that status. one very important thing is, if the checks do not show that you've got settled status, but you think you have, you should not click to say that you will happily take pre-settled status. You should really upload the documents. So I've now come across rather a lot of people who have been here 5 years. For some reason, the checks haven't worked, and they're not completely comprehensive. And so they've clicked and said they're happy with pre-settled status when they really should have got settled status. And given that it's a much better status, we're really urging people to make sure that they get the status that they should. With pre-settled status, you can leave the country for up to 2 years and come back and still have your pre-settled status. However, there's one real hitch in this, and that is that the only status you can move on to is settled status. So you need to have 5 years continuous years of residence to move on to settled status. And so if you're out for more than 6 months, you will break that continuity and you won't be able to get settled status. We've pointed out to the Home Office that this is going to lead to a huge number of problems for people who do leave for more than 6 months. And at the moment, they're very unconcerned about it, and they are not prepared to say that they're going to do anything different. But I think for people need to be aware that although the Home Office letter says you can leave for 2 years and come back, that's fine, but then they have the knock-on effect is that they won't be able to get settled status, and so they will at some point be forced to leave the United Kingdom. So in terms of employment, if you're looking at what you need to see for a European to work, you will be able to see that somebody has made this application if you want to as an employer. You are not obliged to, at the moment, to see any other document other than a passport for a European national. So the right to work lists are remaining exactly the same until right through to December 2020, and will not change. So you don't need to ask your employees whether they've made this application. However, I think it makes sense for employers to be proactive and ask their employees to do this and encourage them to do it, because you don't want to be in a situation at some point where you're not actually allowed to employ them. And so we are urging employers very much to take a positive role and try and encourage their employees to register people. At the moment, processing times are 10 working days if everything's straightforward. However, I suspect that to increase substantially over the next few months because people are now gearing up and applying, and so the quantities of applications is just increasing. The approval, when you do come around to checking whether they're registered on this scheme, the client themselves will be notified by email. So they'll get an email with a letter saying that they have got the status that they need. But they don't actually, the letter actually says that they mustn't rely on it. So what they have to do is show the status in a digital way. They do not get a card. They get no other paperwork, and a lot of European nationals are not happy about this. They're very concerned about this digital way of doing things. The way they can go into their digital status is by logging in with their passport number, and then they will be sent a code. That will then have their photo on there, and everybody will be able to see where they live and all the other details that they've plugged in. So what's very important is if they change their passport, is that they let the Home Office know, because the number will change on the passport and they will only get access to that through their passport. Now, as the employer, what will happen is you would ask your employee to log in. They will get a code. They will send that code to you, and you will be able to verify by going into their portal that they have got the status that you require to allow them to work. This is the way that all immigration documentation is going to go. They've started it with the EU nationals because it's obviously a new scheme that they've been able to set up, but we've been told that this will be rolled out for all statuses in the future. Okay, so important dates. This is where it starts becoming quite complicated. If we get a deal, let's say, yeah. we might know, I suppose, on Saturday. Anybody who arrives before the 31st of December 2020 will be able to register. So that means if you want pre-settled status, if you arrive on the 31st of December 2020 before 11 p.m, you will be able to register on this scheme. You can just put your foot in and that will allow you to stay. You will need to register before the 30th of June 2021. If there's no deal, you need to be in the UK before the exit date. So if we were to leave on the 31st of October, you will need to be in before that date. You will need to register before the 30th of December 2020. If you arrive after the exit date, a European will still be able to work here, but they'll have to apply for what's going to be known as a European temporary leave to remain. They don't have to do that until December 2020, but after that they will. And that will be a visa that's granted for 3 years with, at the moment, no way of extending it. So it's not a very attractive type of leave in the sense that it's temporary, and at the moment it's not clear how it's going to be extendable, if at all.
If I could just intervene and ask you a question, Alison, how do people prove the date of arrival?
So you can either have a document that shows that you're resident with something with your address on, but actually a boarding ticket is sufficient. So as long as you can show that you boarded a flight that arrived in the UK before the cutoff dates, that's enough. Yep.
Okay.
So it's very lax. I'm waiting for the Daily Mail to cotton onto this. So these are the things, just in summary, that employers need to know. No changes to right to work checks until the 30th of June 2021 if there's a deal. So literally you still only have to have a European passport on record, or until the 30th of December 2020 if there's no deal. Sorry, that should be the 31st of December, 31st. And the proof of right to work will be digital. So the one set of people who are still in a problematic situation are what I call frontier workers. So they can continue to work in the UK until the 31st of December 2020. I don't seem to have the 31st, seems to have fallen off my slide. Sorry, it should be the 31st. Unless there is no deal and a new immigration bill is rushed through, which is very, very, very unlikely. So they'll be able to continue to come in. If there's a deal, the Home Office knows that they've got to put in further provisions for frontier workers from December 2020 onwards, because there are arrangements that they will continue to have the same rights as they have now. But at the moment, the Home Office hasn't put anything into their legislation to work that works for frontier workers. So these are people who work in 2 places, or they're resident here, or resident abroad and come here and do a lot of work here. There's no provision for them at the moment. If they are here at the moment and they can say that they're living here, they would be able to grant pre-settled status. But because of the problems that I was talking about before of being out of the UK for more than 6 months, that could lead to problems in the future of them getting settled status. But if we get a deal, definitely watch this space. And even if we don't get a deal, there are a lot of businesses and people who are interested in this area, who are making a lot of fuss about what's going to happen. So I'm sure there will be shifting policy here and things that are worked out, whichever way it goes, whether it's deal or no deal. So then we're looking into the future, and this is really a bit of crystal ball gazing, I'm afraid. If we have a no deal, there will be this European temporary leave to remain, a rather unattractive 3 years. And then what will happen at the end of those 3 years is you will have to go into the new domestic immigration system, of which we know nothing really. So we don't know where we'll be. What we've been told is that there will definitely be new immigration rules in place from January 2021. So it will tail off as the settlement scheme, those deadlines come to an end. We will have a new system, so we'll know what's going on. There had been a white paper that was put out under Theresa May, that we were all discussing like mad and criticising like mad, and we were lobbying already. Of course, when Parliament was prorogued, that fell, and already before that, Priti Patel and Boris Johnson had asked the Migration Advisory Committee to advise on what they're terming an Australian points-based system. Apparently, one of the reasons they're calling it an Australian points-based system is that this goes down very well with voters, because everybody thinks the Australians have a very strict system. In fact, that's of course not true necessarily. They have a very strict asylum system, but they don't have a very strict points-based system or working system. So just having a quick look at what could be involved in an Australian points-based system. A points-based system is usually a system which is granted on the basis of criteria such as age, work experience, language skills, and qualifications. So what happens is it tends to be government driven. The government will decide which areas it thinks are most important at the moment, and it will give points on those bases. So usually it favours well-qualified young people and people who have often studied or had some work experience in that country already. Now, although the Australians do have one of these systems, they also run it in parallel with a employer-driven system where employers can sponsor people in. So there is no reason why we might still have a very similar system with the tier as we have now with the tier 2 system, and have a points-based system running in parallel. In the UK, we have had points-based systems in the past, and the reason that they have been dropped was that they were considered unsuccessful in the sense that although highly skilled people came on them, they were not then taking up jobs that were considered highly skilled. And so the idea of somebody who was extremely well qualified working in pret-a-manger was not really what was considered acceptable. And so gradually we've moved away from them, and Theresa May, when she was Home Secretary, very much abolished them. So we're waiting. The MAC is taking evidence at the moment about these schemes. One of the characteristics that they could put in is to give a lot of points if you already have been offered a job. So that is one way of having a sort of mixed system, and that is something that they're clearly looking at. But at the moment, we just don't know. What is quite good about a points-based system is it can be very flexible in the sense of you can drop the points quickly and a lot more people can come in. And generally, as a general rule, they are used in places which have traditionally allowed a large amount of immigration. So it remains to be seen what happens here. And Priti Patel has announced that she wants a fair immigration system, one that the government can control, but also wants people who can contribute. And it's very much been based on the best people that we can get being invited, rather than any low-skilled immigration, which perversely is, in my experience, what employers are very concerned about. So it remains to be seen what they put in place, and we'll just have to watch this space to see what happens. That's the end. Thank you.
Okay, so Alison, that was great. I just wanted to pitch in, and by the way, if you would like to now type in your questions, we'll be able to read them and respond to them as we go along. But I just wanted you perhaps to touch on another area that's clearly going to be of great concern to us, because you talked about the points-based system, which is really geared to people who are going to have permanent employment in the UK. I think our interest is also about visiting artists around what system might apply to them in a new UK immigration system after December 2020. We obviously currently have the permitted paid engagement system, which treats people as visa nationals or non-visa nationals, and is in relation to the non-visa nationals is really quite light touch and quite successful. We're not hearing many reports of problems with people getting across the border, so long as they're showing that they're here with a legitimate engagement. Would we be insane to assume that rolls forward into a new immigration system, or is your instinct that maybe everything is up for grabs and there could be something totally new?
So my expectation is that short-term categories will very much remain the same, and that these areas will stay the same. they have got so much on their plate sorting out the immigration for workers, that they're not unlikely to touch programs which are short term and which are working, where they don't perceive a lot of abuse. That's what they're concerned with. They want to stamp out abuse, and anywhere where they can have a light touch, they are actually moving towards that. So our immigration system is very much more becoming a risk-based system. And so we see that with the how people have now come in with the scanning on the passport, so they never see an immigration border control person, and that's now been extended to countries which we consider low risk. So I'm expecting those type of visas to remain. I don't think that's not up for grabs at the moment. Now, obviously, that could change, but I think they will leave those alone. They don't perceive huge problems with those, and they don't with the visit visas in any sense at all.
So what we now know is there has been an issue with people coming under permitted paid engagement trying to use the e-gates. And in fact, they have to see an officer. Yeah. And so we would assume that for EEA nationals, it would likely be the same system, which is they need to go and actually present themselves to a human being.
Yes.
And then gain entry.
Yeah, so this is a problem for all sorts of visas, which they hadn't really thought out. So if you get any sort of longer term visa, work visa, for example, as a US national, when you first come in, you shouldn't go through the e-gates. Of course, everybody is, because it just says US nationals. So they've come across this problem not only in the paid engagement visas, but also in other visas. And they're thinking about what they can do about that by what they're hoping to do, or what they've told us they might do, is signpost better when they grant those visas and allow them to come in. But that is a bit of an issue. But I think it's more a technical issue rather than them being concerned about a real risk.
Mm-hmm. And this presumably is going to lead to an enormous investment in additional border officers at every single port of entry in the UK, of which there are many. And our artists are coming in through any number of airports, through Eurostar, even on ferries, I'm guessing. So it will create some, it's additional paperwork for everybody, and making sure that all visiting artists have explained to them what they need to do, because many of them will not have had to do it before.
Well, and also, not only will they not have had to do it before, but immigration officers find it difficult now to keep up with everything. I find it hard to keep up with everything. So I think it's very important that they know what they're doing, so that they can sometimes explain to the immigration officer that they do need a stamp in their passport. They do need to have certain things done when they go through. So I think, obviously, you work with these types of things over and over again, but don't forget that the person who's coming for the first time doesn't know how to do it. So explaining it to them, it can be of great use to them.
Great. Well, I can see we're beginning to get some questions now. Just to clarify, if you could use the Q&A function, that's probably the easiest one. But I have seen a question coming through from Guy at the ISM on the chat. The question is, will the seasonal workers scheme and other comparable schemes be returning?
So at the moment, there's nothing that tells us that they will. The low skilled immigration is a bit of an issue. Obviously, the farmers are lobbying for seasonal workers on their farms, but it's such a political hot potato that nobody seems to want to touch it. I am sure something will come in like this. There will be more flexibility for short-term visas, but in the past, one of the issues on visas like this has been abuse, people overstaying and not going back. And so there are concerns about this. But the government also knows that a lot of EU nationals at the moment do low-skilled work, and without them, we've got to replace them or do something differently. And obviously, training up British people is one way of dealing with some of the problems, but it doesn't really address all the problems. Automation is another way of dealing with some of these things. So I think there will be pressure, but I think what they want to do is sell their highly skilled scheme and their fancy scheme that they say they can control everything, and then slip in something on low skilled, so it'll go much more under the radar. So I think we'll have to look out for it and see what there are.
So obviously the other major area of concern that's come up from the ABO members is going to be how freelancers are going to be dealt with by this, because visiting artists are coming in as freelancers, but for short-term visits, but we have effectively self-employed permanents, people who are choosing to live and work in the UK, and are working for, may have one orchestra of which they're a member, but obviously they're also doing multiple engagements with other orchestras doing private teaching. So where do those people, because at the moment, the tier 2 system for non-EA nationals doesn't deal with them unless the orchestra of which they are a member happens to be giving them enough work in the year to exceed the £30,000 salary threshold. But for many, the orchestra's not giving them £30,000 of work, but they may well be earning above 30,000 from multiple engagements, but at the moment they don't have an employer to sponsor them. So where do you think they're going to fit? Because this is actually crucial for us because they're a vital part of our workforce and our economy.
So at the moment, if they're here already, obviously they can go on to the pre-settled or settled status scheme, and they should. If they're not here already, we don't know. They will be able to get this European temporary leave to remain, but then after that, it's not clear what's going to happen. Again, though, I think self-employment is likely to be dealt with very differently for Europeans than others. We are expecting there to be a slight the understanding that Europeans do come in and out and are much more flexible just because of the proximity of Europe. And we are expecting something to come up on self-employed, but it's not clear yet. And one thing that I know the government has been suggesting is that, well, it'll be fine if they're going to generate revenue and jobs. And we've been saying, well, yes, but that's fine. But there are a lot of people, like the people you described, what are they going to do? I'm afraid that isn't clear at the moment. That is a definite area left for lobbying in this sort of cultural side where individuals come in and are self-employed and are not creating businesses.
Okay, well, that's a job for me then at ABO,
yes, exactly.
is to be pressing this point to the powers that be. If we can just now look in the Q&A bit, so our question from an anonymous attendee is, it appears that PPE will cover EU self-employed artists come to the UK to work for less than 30 days. For longer periods up to 3 months, do you think they would need a certificate of sponsorship?
Yes.
Well, this is actually raises quite a question. The ABO and IAMA have been talking to the Home Office and DCMS for a long time about the inadequacy of the current permitted paid engagement system. When that was first implemented, it only allowed for single entry up to 30 days. A few months back, we got a victory where the Home Office has issued guidance to border officers to say that, in fact, they can allow multiple entry, but it's still up to 30 days. And we know that this is a problem for, particularly perhaps for the opera companies, where they're bringing in singers to rehearse for operas, which takes them over the 30-day limit. And therefore, yes, they are having to do the whole Tier 5 certificate sponsorship system, even if that person's only actually going to come into the UK for 2 months. So I think that does raise this issue around how PPE is not adequate as it's currently written. And we would want in the discussion around future immigration system to push for a review of permitted paid engagement to make it more flexible and more accommodating to the way in which our industry actually works. Alison, anything you wanted to add to that? I mean, this particular question is, I think the question is, yes, you would still need a certificate of sponsorship.
Yes, no, absolutely. I think you would. And I think you're absolutely right. I think this is the time to do it because there is now some recognition that a lot of these people will have been coming in as European. And so I was talking to somebody at the Opera House who said, well, yes, we just fly somebody in for the night if somebody's ill. That's what we do. And I'm like, well, that's not going to be quite so straightforward. So I think it is the time to lobby because the government has now got a much better understanding of the fact that taking Europeans out who can't come in quickly to do shorter term work is going to be problematic. So this is an opportunity to have these types of things looked at again and lobby and revised by the government. And they're up for it. They do understand, I think, that they can't shut immigration down and that they don't want to. They do see a cultural space and a cultural void that could occur if they don't allow these types of people in.
Okay, that was it. That's so far. Any other questions? Please, can you start typing them up right now? Because we haven't got any others, which either means that this has been the most successful webinar and we have dealt with everything as we have gone along. I'm sure, however, that if you wish to reflect on on this webinar and have any further questions, please email them through to the ABO. We will forward them on to Alison and get her opinion on it and get that information back to you. We will also potentially, I suppose, have some kind of fact sheet that we might be able to develop from this. We'll also, of course, be able to make the presentation available for people to refer to. I believe too, we are recording this webinar and therefore we'll be able to make it available for people to view again. Thank you for the comment saying this has been really helpful. That's extremely good to hear, because it's slightly odd talking into what feels like a void, but to know that actually you are there, you are listening to us, and it has been useful. So if there are no further questions, I think this has been a very useful exercise. It certainly helped me. It means that the ABO has got some work to do, particularly around the permitted paid engagement. We obviously encourage you to make sure that all your current employees who are EU nationals and your musicians who are EU nationals we have got, quickly, another question. So after we leave the EU, will EU nationals need to enter for short-term work on the PPE system? I think we've dealt with, that's what the question I put to Alison. This is the bit where we don't know, but we would assume so. Our assumption is that the current permitted paid engagement system for non-EEA nationals will be extended to include EEA nationals. But this is something we need to get clarity on, because the government has not mentioned PPE in its discussions around a future immigration system. And that's why I'm saying that one of the ABO's tasks now, in collaboration with IAMA, is to push for clarity on how PPE will work after 31st December 2020. But yes, the question, I think the answer to that is probably. They will probably need to enter on the PPE system. So yes, so basically we will take forward some of the issues that are being raised here. Get your EU nationals who are with you now. Yes, another, question that's come through on the chat field. Will EU nationals be able to enter visa-free? Actually, this is a question I put to you, Alison, before we started the webinar. We will be treated, will we not, as everybody within UK and EU will be non-visa nationals?
Yes, so that's definite. They will be non-visa nationals. So if you're only coming to visit, you won't have to get a visa. Obviously, if you're coming to do a work or something else here, you will have to get a visa. So, but this is all from 2020 onwards. So yes, we're expecting them to go into the tier 2 system and basically be treated like non-Europeans are treated at the moment.
Okay, right, more questions are coming in. Thank you, this is brilliant. Right, will the conditions for being classed as a frontier worker remain the same in terms of how frequently they work in the UK and return to their home countries? I have an EU client who works regularly in the UK every few months, for a period of a few weeks at a time, assuming he will just need a certificate of sponsorship.
So you won't be able to give him a certificate of sponsorship if he's not working here. So he will need to be here. You can't have somebody who's just dipping in easily on a certificate of sponsorship on a tier 2. They have to be here permanently. So that's problematic. EU frontier workers are the ones you need to look out for. Until December 2020, they're fine. If we get a deal, they will definitely have to be covered as now. So they have to, the UK will then have to make provision for them in the same way as they're treated now. But if we don't get a deal, they're highly problematic, because the UK government has said they don't see why people should just come in, work here for a bit and then disappear again. That's not what they want their immigration system to be. They want people to come in, reside, be part of everybody else and become integrated here. So I think that is a, you have to watch this space on that question, I'm afraid. It's not clear.
Okay. I'm going to jump ahead to another one which relates to A1 certificates, because actually here this is me who's going to give you what we understand about the future for social security coordination. This is a big problem, and this was discussed at the workshop that we did at King's Place a couple of weeks ago. And this is one of the biggest hot potatoes that we're facing in terms of touring taking orchestras and artists across into the EU. And this is a no-deal problem. Effectively, in the event of a no deal, UK issued A1 certificates cease to be valid, and the UK government will cease to issue A1 certificates because the A1 certificate is linked to the EU-wide posted workers system. So this is very scary because it creates the situation in which it is possible for the orchestra to face a double charge on all the social security, because the musicians will be paying their social and staff paying their social security in the UK, but the EU nation has the right to then charge social security on the work that's being taking place on their soil. And that creates a double charge, and with no rebate system. And this is creating a potential liability of tens of thousands of pounds for some ABO members in terms of the tours that they've got taking place in the EU after 31st of October. We do not have what the UK government has done is made an offer to all the EU 27 countries to carry on existing social security coordination arrangements until 31st of December 2020. So far, only Ireland has said yes. France has said no. It will not recognise UK issued A1 certificates. And none of the other countries have said anything. So we literally do not know, apart from Ireland and France, whether there will be a demand for social security or not. The UK government has just said, from its perspective, it's not going to demand social security of any EU national coming in after no deal Brexit, which is very magnanimous of them. But then it turns out that they're not doing that anyway. And in fact, nobody in the UK is having any EU national coming into the UK is currently not presenting an A1 certificate to anybody. Unlike, as we know, where these rules are rigorously enforced, particularly by France, Spain, and Italy. So that's a complicated answer to a very good and simple question, which is, so all I can say is EU nationals will not need to show an A1 in the UK. There's no expectation of that, and the UK government doesn't want to bother because it means setting up yet another whole load of bureaucracy. It's the other way that's the problem, UK nationals going into the EU, where they will not be able to present A1 certificates if those A1 certificates cease to be valid. The deal does include social security coordination. So if the deal is passed tomorrow, we can breathe for a bit, because it at least means that social security coordination continues to 31st of December 2020. There's still the question of then what happens in terms of the free trade agreement between the UK and the EU after that date. So no, A1s are leaving us with quite a lot of questions. And we are preparing our members as much as we can to there's going to have to be, if there is a no deal Brexit, some contingency planning around potential financial liability. And then jumping back to another question, which is about instrument passports and carnets. Yeah, this is an immigration webinar, so it is left field, but this was covered again in our workshop in London, will be dealt with in our workshop in Manchester on the 30th of October. But basically, in the event of a no deal, carnets will be required. And music instrument certificates for any instruments containing CITES listed species. And the ABO has got on its fact sheet a list, links to lists of ports that you would need to use to get certificates inspected. And we did a bit of a carnets workshop with our members in a couple of weeks ago. People are going to have to get geared up for that. Now, my understanding is in the deal, again, that's about buying time. So it should, I think, ease off, and those restrictions won't come in. And then we'll need to understand what happens with the free trade agreement after 31st of December 2020. So we're all effectively, I know there are a lot of arguments about, a lot of people who are passionate Remainers don't want this deal to go through. But if it doesn't go through, then there is the worst case scenario of a no deal Brexit, which will be significantly worse. So we will be keeping you updated as and when we know what happens in the next stages. Right, are there any other questions coming through? No, so back to my little, right, so back to the summing up. Get your current EU nationals through the settled status system. Future EU nationals depends on deal or no deal, but with luck, if there is a deal, then it's around continuing that settled status system through to 31st December 2020. ABO will then be arguing its case around what the future immigration system, how that should work to our advantage. We will just keep ABO and IARM will keep everybody informed around what develops in terms of future immigration. I hope this has all been very useful. It's good for me because it's helped me recap on exactly where we are. We're not seeing any further questions coming through, in which case, if everybody is happy, we will wish you goodbye. Do please, as I say, any questions, just email them through, we'll deal with them. I'd like to give a huge thanks to Alison for bringing her expertise into the room today. Very important, great that we have this wonderful contact in the legal system to help us with these very important questions. Thank you, Emily, who's been by my side dealing with the technical issues. And we wish you all very well. And the key thing is that we're going to continue to have great authors and great artists flowing between the UK and the EU. We have to make that happen. And with all our collective energies, I'm sure that we will be fine. So thank you all, and hope to see you at future ABO events or even possibly future webinars. Thank you all very much for attending. Hope you all have a very good rest of the day. Thanks.